What happened in the federal courthouse yesterday was not just a legal debate. It was an event that left Supreme Court Justice Coney Barrett visibly shaken and sent a shockwave through the highest echelons of the American legal community. It all unfolded as a former high-ranking Defense Department official, Kash Patel, delivered a response that, in the span of just a few minutes, completely altered the trajectory of a landmark hearing. A judicial conference that began as a routine gathering of legal minds was irrevocably transformed into one of the most stunning and consequential confrontations in the annals of modern legal history. All because Justice Barrett made a comment that crossed a deeply respected line. "No federal judge should ever approach," she had been saying before her fateful turn of phrase. Perhaps Mr. Patel would be more comfortable practicing law in his own country. The words, spoken with a clear and unmistakable air of dismissiveness, hung in the air of the silent courtroom. This comment came just after Patel had dared to challenge her deeply held interpretation of executive privilege. In that precise moment, every single person in attendance understood that a critical boundary, one of professional respect and fundamental decency, had been grievously breached. The response that followed was nothing short of a masterclass in constitutional law, a powerful display of professional dignity, and a profound statement on American identity that no one present will ever be able to forget. If you are tired of witnessing highly qualified and dedicated professionals endure these kinds of remarks, regardless of their extensive years of service to the United States, then you will want to see exactly what happened next. Hit that like button and subscribe, because Kash Patel's measured response didn't just reshape the course of this one hearing. It may very well have changed how the Supreme Court itself approaches fundamental questions of patriotism and belonging for many generations to come. To truly grasp why this single confrontation sent such powerful tremors through America's intertwined legal and political establishments, it's essential to understand who these two towering figures are and why this unexpected, explosive clash had been quietly brewing just beneath the polished surface of Washington's corridors of power. If you are finding this in-depth analysis valuable, please take a moment to hit that like button and subscribe to our channel. We are committed to bringing you these detailed breakdowns of the crucial moments that the mainstream media often overlooks or simplifies. Your support is what allows us to continue this vital work. Supreme Court Justice Coney Barrett, now 52, has been a member of the nation's highest court since her highly contentious confirmation battle back in 2019. Armed with a prestigious education from Notre Dame and a solid background as a federal appellate judge, Barrett swiftly carved out a reputation for herself as a steadfastly reliable conservative voice on the bench. Her devotion to a textualist approach for constitutional interpretation, combined with her well-known religious conservatism, has made her a deeply polarizing figure in the landscape of American jurisprudence. Since ascending to the Supreme Court, Justice Barrett has generally projected a restrained and careful public persona, meticulously cultivating an image of scholarly detachment and unwavering judicial temperament. Her legal opinions have, for the most part, aligned predictably with the court's conservative wing, especially on contentious issues involving the scope of executive power, the extent of religious liberty, and the reach of administrative law. The judicial conference where this historic confrontation took place was specifically focused on the delicate boundaries of executive privilege and national security, topics that have grown increasingly fraught in recent years. Justice Barrett was the keynote speaker for the event, which had brought together a distinguished assembly of federal judges, renowned legal scholars, and senior government officials for what everyone anticipated would be a collegial and academic discussion of complex constitutional questions. Kash Patel, aged 45, enters this arena from a completely different world, bringing with him a unique perspective and a compelling life story. Born in Garden City, New York, to parents who had immigrated from India, Patel has constructed an impressive and distinguished career in service to the United States, holding multiple high-level national security positions. After completing his law degree, he began his career as a public defender before making a pivotal move to the Department of Justice, where he served as a dedicated national security prosecutor. In this role, he took the lead on a number of high-profile cases involving international terrorism. Patel's career in public service expanded dramatically when he was brought onto the National Security Council, where he eventually rose to the position of Senior Director for Counterterrorism. His recognized expertise in these sensitive areas ultimately culminated in his appointment as the Chief of Staff to the Acting Secretary of Defense, a position from which he helped to oversee the vast and complex machinery of the entire United States military and its global intelligence apparatus. Throughout his long and varied career, Patel cultivated a well-earned reputation as a formidable legal intellect, possessing a particularly deep expertise in the specialized fields of national security law and executive authority. Despite being embroiled in occasional political controversies, even his most ardent critics had to acknowledge his profound understanding of classified information protocols and presidential power, knowledge that was directly and immediately relevant to the central themes of the conference. What was not widely known before the event was that Patel had recently put the finishing touches on a comprehensive and meticulously researched law review article. This article directly challenged several of the prevailing interpretations of executive privilege, including some of the very positions that Justice Barrett herself had publicly endorsed in her recent court opinions. His incisive analysis, which was heavily fortified with deep historical research and legal precedent, raised serious questions about whether the Supreme Court's current approach was adequately balancing national security concerns against the Constitution's essential checks and balances. The stage for this dramatic confrontation was perfectly set when the conference organizers announced that there would be a question and answer session immediately following Justice Barrett's keynote address. Attendees who were present later reported that Barrett's speech had adopted a surprisingly partisan tone, as she dismissed legitimate concerns about the expansion of executive authority as little more than hysterical overreactions from individuals who, she implied, did not properly grasp the nuances of American governance. When the floor was finally opened for questions, Kash Patel was among the several distinguished experts who raised their hands. No one in that room could have possibly predicted that this particular exchange would produce one of the most remarkable and unforgettable moments in the recent history of the Supreme Court, or that an unguarded and ill-conceived comment from Justice Barrett would so starkly expose the deep tensions surrounding belonging and patriotism that quietly run through the very heart of America's legal establishment. The grand ballroom of the Washington Legal Conference Center was filled with an audience of nearly 400 legal professionals when Justice Barrett brought her formal remarks on executive privilege to a close. The moderator, a highly respected federal judge from the D.C. Circuit, officially opened the floor for questions, carefully establishing the ground rules which emphasized the importance of professional courtesy and brevity. We'll be taking questions from the floor, but please identify yourself and your affiliation before you speak, the moderator instructed the expectant audience. Several hands shot up almost immediately, and the moderator's gaze settled on Patel, who was seated toward the middle of the crowded room. "Thank you, Justice Barrett, for your remarks," Patel began, rising to his feet and speaking in a voice that was both clear and measured. "I am Kash Patel, former Chief of Staff at the Department of Defense and a National Security Council official. I'd like to ask about your interpretation of United States versus Nixon and how it applies to classified documents in our modern digital age." Barrett gave a slight nod, appearing to recognize Patel's name. "Of course, Mr. Patel. I'm familiar with your government service." Patel pressed on. "In your recent concurrence in Department of Justice versus Richards, you seem to suggest that executive privilege should be extended to cover all communications that involve national security. even when those communications take place outside of official government channels. I'm concerned that this interpretation lacks a firm historical foundation and could potentially enable a level of executive overreach far beyond what the framers of the Constitution ever intended. A subtle but noticeable tension began to creep into Justice Barrett's expression. I believe my opinion very clearly addressed the historical basis, Mr. Patel. The vesting clause grants the President significant latitude in matters of national security. With unwavering respect, Patel responded, "With all due respect, Justice Barrett, I have reviewed the historical record quite extensively for a forthcoming article in the Yale Law Journal. The evidence strongly suggests that the framers specifically intended to prevent presidents from using broad claims of national security to shield potentially improper actions from necessary congressional oversight." Patel then proceeded to reference several founding-era documents that directly contradicted the historical analysis Barrett had put forward. Madison's notes from the Constitutional Convention explicitly reject the notion that executive privilege could ever be absolute, even in matters of national security, and President Washington himself established the precedent of providing sensitive documents to Congress when they were requested. The room grew discernibly quiet as the attendees began to realize that they were witnessing something far more significant than a polite academic question. This was a substantive, direct, and well-armed challenge to Justice Barrett's core constitutional interpretation. Barrett's expression hardened, shifting from mild annoyance to visible irritation. "I appreciate your historical interest, Mr. Patel, but the court's jurisprudence has evolved considerably since the founding era. Contemporary security challenges require a level of flexibility that the founders simply could not have anticipated." Patel nodded respectfully, but did not yield his ground. "The principles haven't changed, though, Justice Barrett. The balance of powers remains foundational. In my role overseeing classified information at the Defense Department, I observed firsthand how expansive claims of privilege can be used to conceal information that Congress legitimately needs to conduct its oversight duties." He continued with remarkable precision, citing specific cases that undermined Barrett's position. In Nixon, Justice Powell's concurrence specifically warned against using national security as a blanket justification for withholding evidence. And in the Pentagon Papers case, the court rejected national security claims in the absence of specific showings of harm. Barrett's irritation was now plainly visible to everyone in the room. "Mr. Patel, these are complex constitutional matters with significant nuance. Perhaps you are approaching this from a political rather than a legal perspective. Who do you think is winning this exchange? If you stand with Justice Barrett's perspective, type Barrett in the comments below. If you support Kash Patel's argument, type Patel. We want to know who you think is right." "My approach is constitutional, Justice Barrett," Patel replied, his voice remaining calm and steady. "I have enforced these principles from inside the executive branch, where I witnessed both the legitimate need for confidentiality and the profound dangers of excessive secrecy. The Constitution requires balance, not the near absolute privilege that your recent opinions appear to endorse." It was at this juncture that Justice Barrett made the critical, unforced error that would come to define the entire exchange. Her composure finally slipped, and she said, "Perhaps Mr. Patel would be more comfortable practicing law in his own country, where different constitutional arrangements might better align with his views." A shocked and heavy silence immediately fell over the room.
Several attendees could be seen exchanging glances of sheer disbelief that a Supreme Court justice would direct such a remark at a former high-ranking U.S. official, particularly one who was born and raised in the United States. The moderator seemed momentarily frozen, utterly unsure of how to proceed after such a flagrant breach of judicial conduct. Patel stood perfectly still, his expression composed and unreadable despite the gravity of the insult. The silence stretched for several long, uncomfortable seconds before he finally responded.
"Justice Barrett," he began, his voice unwavering and clear. I was born in Garden City, New York. I am a graduate of American public schools and American universities. I have prosecuted terrorists who threatened this country. I have advised presidents on protecting American lives, and I have helped to oversee the United States military. The room remained in absolute, rapt silence as Patel continued. The Constitution I am referencing is not foreign. It is the very document I swore an oath to defend throughout my many years of government service. It is the same Constitution that I carried in my pocket during sensitive national security briefings in the Oval Office and at the Pentagon. At that moment, Patel reached into his jacket and calmly removed a worn, pocket-sized copy of the Constitution. This is my country, Justice Barrett. I have spent my entire career serving it, defending it, and upholding its founding principles, including the critical checks and balances that are designed to prevent any single branch of government from amassing unchecked and absolute power. Several attendees later reported that Justice Barrett's face had visibly paled as the full weight and inappropriateness of her comment, suggesting an American-born public servant should go back to his country, became starkly clear to everyone present. But Patel was not finished. With a remarkable display of restraint, he pivoted immediately back to the substance of the legal argument, rather than dwelling on the personal slight. The constitutional principles that I am defending are not foreign imports. They come directly from Madison, Hamilton, and Washington. My forthcoming article documents in extensive detail how the framers explicitly rejected the kind of expansive interpretation of executive privilege that you have endorsed in your recent opinions. He then proceeded to outline, with the precision of a scholar, the historical evidence that contradicted Barrett's position. The historical record is unambiguous. The framers intended for executive privilege to be qualified, not absolute, even in matters that touch upon national security. My concern is not political. It is about preserving the system of checks and balances that is absolutely essential to our constitutional order. Several prominent constitutional scholars in the audience were now nodding in clear agreement with Patel's legal analysis. His masterful command of founding-era sources and Supreme Court precedent was undeniably impressive, a fact that only made the inappropriate nature of Barrett's earlier comment even more glaring. The moderator finally found her voice and attempted to steer the session forward. "Thank you, Mr. Patel. Perhaps we should take another question." But Patel raised his hand slightly. "If I may add one final point, since Justice Barrett raised the question of belonging." The moderator hesitated for a moment, then nodded her assent. "The beauty of American constitutionalism," Patel continued, "is that it belongs to all Americans, whether their families came over on the Mayflower or, like mine, immigrated more recently in search of the American dream. Constitutional interpretation is not the exclusive domain of any one background or any single perspective. Indeed, our national conversation about the meaning of the Constitution is enriched and strengthened by a diversity of viewpoints, united by a shared commitment to its founding principles." A murmur of approval began to spread through the audience. What had started as a deeply uncomfortable and inappropriate moment was now transforming into something far more significant, a powerful and resonant affirmation of constitutional principles and the very nature of American identity. The aftermath of the Barrett-Patel exchange was both immediate and far-reaching. By that evening, video clips of the stunning confrontation had gone viral across social media and various legal forums. The hashtags #HarsConstitutionalScholar and #ThisIsMyCountry2 began trending nationwide, with the video of the exchange generating over 12 million views in just 36 hours. Legal scholars from all across the political spectrum began to weigh in on both the substance of the constitutional exchange and the shocking nature of Barrett's comment. The initial focus of major news outlets was on Barrett's "Go to your country" comment, with headlines highlighting the deeply inappropriate nature of suggesting that an American-born public servant was somehow foreign. However, the substantive analysis quickly and rightly turned to the critical constitutional issues that Patel had so powerfully raised. Within 72 hours, the Chief Justice of the Supreme Court, John Roberts, took the highly unusual step of issuing a public statement. The court remains committed to treating all members of the legal profession with appropriate respect and dignity, regardless of background, the statement read. Robust constitutional debate strengthens our legal tradition when it is conducted with mutual respect. While it did not mention Justice Barrett by name, the statement was universally interpreted as a direct response to her comment. Barrett herself issued her own statement the following day. At yesterday's conference, my choice of words during an exchange with Mr. Patel was inappropriate and does not reflect my belief that constitutional dialogue should be inclusive and respectful. I have reached out to Mr. Patel directly to express my regret for the comment. Notably, her statement made no mention of the substantive constitutional criticisms Patel had raised about her executive privilege jurisprudence, an omission that was highlighted by numerous legal commentators. Patel's response demonstrated the same profound dignity he had shown during the original exchange. His brief statement read, "I appreciate Justice Barrett's acknowledgement and consider the matter resolved on a personal level. I remain focused on the constitutional questions regarding executive privilege, which have significant implications for our system of checks and balances." The impact extended far beyond the immediate exchange. Law schools across the country requested permission to use the video of the confrontation in their constitutional law courses. Georgetown Law Center promptly announced a symposium titled Executive Privilege Reconsidered, with Patel as the keynote speaker. Legal databases reported a nearly 400% increase in downloads of historical articles related to the limitations of executive privilege. For the Supreme Court, the incident created significant institutional challenges. A national poll conducted 3 weeks after the exchange found that 68% of Americans considered Barrett's comment to be inappropriate, with broad agreement across partisan lines. More substantively, legal analysts began to notice a subtle but discernible shift in how the court approached cases involving executive privilege. In a Chambers opinion issued just a month after the conference, Justice Kavanaugh cited several of the same founding-era sources that Patel had referenced during the exchange. For Patel, the incident dramatically elevated his standing within the legal community. His forthcoming Yale Law Journal article on executive privilege received an unprecedented level of attention, with the online version being accessed 250,000 times in its first 10 days. A record for legal scholarship. Perhaps most significantly, the exchange ignited a broader national conversation about belonging, expertise, and constitutional interpretation. 18 months after the conference, the impact continued to reverberate when the Supreme Court heard oral arguments in a major executive privilege case. Several justices asked questions that directly referenced the historical sources Patel had highlighted. When the decision was announced 4 months later, constitutional scholars were stunned to see Justice Barrett's concurring opinion, which took a noticeably more limited view of executive privilege than her previous writings. While she did not cite Patel directly, her opinion referenced several of the founding-era sources he had so effectively used during their exchange. For everyday Americans, particularly those from immigrant backgrounds, the Patel-Barrett exchange became a powerful symbol of a patriotism based on constitutional principles rather than on background or appearance. 18 months after the conference, the American Constitution Society created the Patel Prize for Constitutional Dialogue, to be awarded to legal scholars whose work promotes thoughtful engagement across jurisprudential differences. The exchange between Barrett and Patel ultimately transcended a momentary confrontation to become a seminal case study in constitutional dialogue, American identity, and professional dignity. But the story doesn't end here. As the political landscape shifts, new alliances and unexpected conflicts are emerging between these two powerful figures. Make sure you subscribe and turn on notifications, because the twists and shocking developments to come will change everything you think you know, and you must watch until the very end to see what happens next.